And that's a big misconception about a lot of things, about other types of leave, but also about this leave. And the unequivocal answer is no, they don't have to exhaust any of those leaves. Often, obviously, personal carers leave can often be part of or relevant to family and domestic violence leave. So previously they would have taken it as a personal leave or carers leave. So they do not have to exhaust all of those, and it's got to be looked at as separate to those. And what you will find and employees will do is they'll access the 10 days which doesn't accrue to year to year and preserve as much as possible the personal carers leave, because that does accrue year to year. So, and that's understandable. So what an employer needs to also understand, though, is if an employee is out on personal carers leave or is in fact on annual leave or long service leave, in any of those types of leave, they can turn around and say, sorry, I need to convert Monday, Tuesday, Wednesday to family and domestic violence leave because I was dealing with matters I could not otherwise deal with. Again, they've got to provide the evidence. Again, it's got to be the perpetrator we talked about, but they are entitled to have that leave converted. So there's a big misconception about that, because it's still the same if you're on annual leave and you go sick. Technically, you can tell your employer, I'm actually sick Monday, Tuesday, Wednesday, convert my annual leave to sick leave. And as long as they've got the evidence, you as the employer are required to do that. So I think it's important to look at it standalone, but also look at it with those other forms of leave, and certainly don't be saying anything like, I'm not giving you those 10 days until you've got no sick leave, because that's just not, or personal leave, that's just not the case.